All right. I believe we are ready to get started. And so I will call cause number 10,858 for the case styled the state of Texas versus Jacob Fear Dreger. This is a plea hearing wherein the plea papers that have been presented to the court indicate that the defendant desires to enter a plea of guilty to the charges in the indictment, but to do so pursuant to a plea bargain agreement between defense and state. It is with those understandings that the case is called. Before calling for announcements, let me first make a couple of announcements myself. This hearing is being conducted by remote video teleconferencing technology using the Zoom protocol. No participants are present in the courtroom itself. This hearing is also being live streamed on the court's YouTube channel. Both of those electronic matters are being accomplished in order to satisfy or to comply with the Texas Supreme Court's orders and rules and regulations issued by the Office of Court Administration. Since we are using an electronic means of making this proceeding available to the court announces that all parties are expressly prohibited from recording. And when I say all parties, I mean including those who are observing the proceedings electronically. Each person is prohibited from recording this proceeding through any means whatsoever, be it the Zoom recording function or the recording function on the court's YouTube channel, whether that is done electronically, photographically, or in any other manner. With those announcements being made, I first call upon State's Counsel. Is the state ready to proceed?
State's ready, Your Honor.
And Ms. Brooks, on behalf of defense, is defense ready to proceed?
Defense is present and ready, Your Honor.
And Mr. Dreger, are you Jacob Fear Dreger?
Yes, sir.
Are you in fact ready to proceed?
Yes.
Mr. Dreger, I will have a conversation with you about this plea hearing and the documents that have been placed in front of me. Let me begin by saying and telling you that you have the right to have someone read the indictment in your case out loud to you during this proceeding. Do you wish to have someone read the indictment out loud to you?
No, sir.
Do you understand that the indictment in this case charges you with a third-degree felony offense of driving while intoxicated?
Yes, Your Honor.
Then, understanding what the charge is to those charges, how do you wish to plead? Guilty or not guilty?
Guilty.
Do you understand that you do not have to enter a plea of guilty? You have the absolute right to enter a plea of not guilty. And further, you have the right to not have it used against you just because you might exercise that right. Do you understand that?
Yes, sir.
Then, understanding the charge, to the charge of driving while intoxicated, alleged as a third-degree felony, how do you wish to plead to that charge? Guilty or not guilty?
Guilty, Your Honor.
I apologize, sir. I've already asked you that question, and I didn't mean to be redundant. Let me go further and tell you, you have other rights and admonitions I need to discuss with you. You have the right to have a minimum of 10 days notice of the charges against you before being required to stand against those allegations in the indictment. You've had more than 10 days notice. Nevertheless, I will grant to you some additional time if you need to have it. You also have the right to have a jury hear your case. And that's true, even though you might enter a plea of guilty, as you just indicated a few moments ago that you wish to do. Do you understand that you have the right to a jury trial?
Yes, sir.
Now, I have been handed a document entitled Waiver of Defendant, and that document says you're giving up the opportunity to have more time to prepare, and you're giving up the right to have a jury hear your case, which means I will hear your case by myself without a jury, and we will do so today. Did you understand that that was the effect of the document you signed entitled Waiver of Defendant?
Yes, sir.
And is that what you still wish to do?
Yes, sir.
Ms. Brooks, your signature is also on this Waiver of Defendant document. Is that evidencing that you are giving up, you are joining your client in the waiving of these rights set out in that document?
Yes, Your Honor.
Let me pause for just a moment. It's pointed out to me that our representative from the probation department has not joined our Zoom hearing. So let me pause for just a moment and see if I can't correct that. Ms. Phipps, are you checking on that?
Sure.
While that's being done, let me proceed as I was discussing this waiver of defendant document and note that, Mr. Smith, your signature is also on the document along with Mr. Dreger's and his attorney, Ms. Brooks. Did you sign this document to evidence that the state is joining in the waiver of the right to a jury trial?
Yes, Your Honor.
All right, I announce that I will accept these waivers in the waiver of defendant document and announce that there are other rights and admonitions that I need to discuss with Mr. Dreger. First of all, Mr. Dreger, am I pronouncing your name correctly?
Yes, Your Honor.
All right. Let me begin in discussing these other rights and admonitions with you by telling you the range of penalties that exist for a charge such as exists in this document. The charge, I say document, exists in this case. The charge of driving while intoxicated as a third-degree felony carries a range of penalties running from not less than 2 years to not more than 10 years in the Texas Department of Criminal Justice. It also carries the possibility that a fine could be imposed. And if a fine is imposed, the fine could be in an amount not to exceed $10,000. Now, do you understand that's the possible range of penalties you face if you were to be convicted of the charge in this indictment?
Yes, Your Honor.
And let me proceed with the discussion of this plea and tell you that, as I mentioned earlier, I'm aware that a plea agreement exists in your case, but that I do not have to follow the plea agreement. I have to tell you if I'm going to follow it or not. Because if for some reason I decide not to follow your plea agreement, the law would recognize another right belonging to you at that time, which would be your right to withdraw your plea of guilty. Restated, hopefully in a simpler way, if I don't follow your plea agreement, you have the right to take back your guilty plea and we would just start all over. Do you understand that?
Yes, Your Honor.
Now let's talk about what happens if I do follow your plea agreement. If I follow your plea agreement, then you will be bound by the terms of that plea agreement, and you will not be able to get out of the terms of the plea agreement, even by changing your mind or filing a notice of appeal. And so let me talk about that. Ordinarily, there is a right to appeal for anyone, even somebody who has a plea bargain agreement, except if a term of the plea bargain agreement itself says that you're giving up the right to appeal as a part of the plea agreement, then that term means what it says and is enforceable, and it means that you cannot appeal. If I follow your plea agreement, because your plea agreement has that term marked that says you're giving up the right to appeal, if I follow that agreement, it means what it says, and you will not be able to appeal at all. Do you understand that principle of law?
Yes, Your Honor.
Then let's go further in this plea discussion, and I ask you, are you a citizen of the United States of America?
Yes, sir.
Do you understand the charges in this indictment so that you can discuss those charges with your attorney and get her advice about what the law is, and how the law might affect the facts of your case, or the law could be affected by the facts of your case, one way or the other? Do you understand that you have had an opportunity to communicate? I'm sorry, that you have the right to communicate with your attorney about all these matters. Do you understand that?
Yes, Your Honor.
And have you in fact been able to talk to her and visit with her about your case?
Yes, I have.
And have you also heard her advice about what the law is and how the law, as I was saying earlier, how the law affects your case? Have you been able to do those things as well?
Yes, Your Honor.
Ms. Brooks, are you satisfied that your client is mentally competent?
Yes, Your Honor, I am.
All right, I accept that representation. It's obvious to the court that Mr. Dreger is mentally competent, and so I make that finding. Mr. Dreger, there are other matters I need to discuss with you. And let me tell you that we're about to be joined by the probation department. So if you see Mr. Oliver there pop up on your screen, he is from the probation office and he is joining us in this plea discussion. Now, there are some other questions I need to ask. I'm required by law to ask of you, sir. And so I do ask. The first one is, are you a citizen of the United States of America?
Yes, Your Honor.
Where were you born?
In Mexico.
Are you already a citizen of the United States?
No, Your Honor. I applied for residency in 1988, and then I became a citizen 10 years after that.
All right. Well, I need to tell you that a conviction for a felony has the capability of resulting in deportation. It has the capability of resulting in exclusion from admission to this country, or even denial of naturalization under federal law if you were excluded and attempted to move back into this country. Do you understand that provision of the law?
Yes, Your Honor.
My next question asks you, are you well, let me preface my next question by stating that I must be satisfied that you are mentally competent. And so I do ask you, do you consider yourself at this time to be mentally competent?
Yes, Your Honor.
And that goes back to the questions I was asking just a little bit ago about your discussion of the case with your attorney. You told me that you were satisfied. Your attorney believes you're mentally competent, and I do as well. And I accept your representation that you are. My next question asks, are you satisfied with the legal representation your attorney has provided to you in these matters?
Yes, Your Honor.
And let me tell you why I asked that question, because I'm not trying to suggest that you wouldn't be or shouldn't be satisfied with your attorney's work. I instead asked that question just so you would have a chance to tell me if you thought your attorney was not satisfactory, if you thought your attorney was somehow operating at a legally ineffective or deficient manner. That question would give you the chance to tell me if you thought that were the case, and we could work to correct any deficiencies, if any existed, in your attorney's work. But I also tell you, that since I asked you the question now about your attorney's legal performance, so to speak, to give you a chance to tell me so I could correct any problems if they existed, that effectively means you're not likely to be successful if you wait to some later date to say your lawyer didn't do a good job. Now, if you think that's the case, is the time to raise that question. Do you understand that?
Yes, Your Honor.
And understanding that, are you still, that proposition, are you still telling me you're satisfied with your attorney's representation?
Yes, Your Honor.
All right, so then one other question I'm required by law to inquire into or to be satisfied about is whether or not you are deciding to enter into this plea of guilty on your own free and voluntary will. I'm required to be satisfied that that's the case. And so I ask you, has anybody threatened you or forced you or tricked you or in any way tried to make you enter a plea of guilty to this charge when you would not otherwise do so?
No, Your Honor.
Has anyone paid you anything or offered to give you anything of value just to get you to enter a plea of guilty when you would not otherwise do so?
No, Your Honor.
Are you telling me then that you're pleading guilty to this charge because the truth is you are guilty of this charge, and that's the only reason you would plead guilty to such a charge?
That is right, Your Honor.
All right, I announced that I will proceed with this plea hearing. Mr. Smith, you may proceed.
Your Honor, the state offers for evidence a document marked as State's Exhibit 1. State's Exhibit 1 being this defendant's signed and sworn stipulation of evidence in this case.
No objection, Your Honor.
And let me talk to you about the stipulation of evidence, Mr. Dreger, that the state's attorney has just offered. It also bears your signature. And so let me discuss that with you, not your signature, but the document. And in doing so, let me tell you of some other rights that seem to exist or seem best to discuss at this point in the proceeding. I tell you that the state is required to produce some evidence tending to show your guilt, even though you plead guilty to the charge. And that's a part of our law, as I understand it, because it helps to ensure that another right that belongs to you is in fact provided to you. That other right is what we call the right to confront the witnesses against you. And that merely means you have the right to require the state to bring their witnesses into court to be sworn in and to testify so that you can see them and hear them as they give that testimony. But this stipulation of evidence says you're giving up that right, and you're telling the state as well as the court that the state doesn't have to bring their witnesses into court at all because you're waiving that. You're giving that up, that right to confront those witnesses against you. Did you realize you were giving up that right, the right to confront the witnesses against you, when you signed the stipulation of evidence?
Yes, Your Honor.
Now, you also, there are other rights mentioned. You also have the right to be, you also have the right to remain silent and the right to be free from self-incrimination, which is the right to not be forced to give evidence against yourself. And instead, you are giving evidence against yourself because this stipulation of evidence says not only are you pleading guilty, but you are also admitting that all of the material allegations set out in the indictment are true and correct. That admission is thus a confession, confessing to have committed the offense. And that confession provides the state with the very evidence I mentioned a moment ago they have to produce. Did you realize that through your confession, you were admitting that all of those material allegations in the indictment are in fact true and that you committed the offense just like it is alleged in that indictment? Did you realize that when you signed the stipulation of evidence?
Yes, Your Honor.
All right. Then State's Exhibit 1, the signed sworn stipulation of evidence is received as evidence in this case.
State rest, Your Honor.
Defense rest, Your Honor.
State closes.
Defense closes.
All right, Mr. Dreger, based upon your plea of guilty, based upon the evidence you stipulated to in this cause, I find that you are guilty of the offense of driving while intoxicated, a third-degree felony. That said, do you know of any legal reason why a sentence should not be announced at this time?
No.
All right, sir. Then based upon your plea of guilty, based upon having already found you guilty of this charge and there being no reason not to announce sentence at this time, then I announce that I hereby sentence you to serve 8 years confinement in the Texas Department of Criminal Justice pursuant to the plea agreement. But I want to discuss the rest of the plea agreement with you. The plea agreement, as I just alluded to, says you will plead guilty as you did and have done, and that would result in an 8-year sentence to the penitentiary. It also says you will pay a fine of $1,600. It says that you will pay court costs in the sum of $290, as well as paying reimbursement fees totaling $690. The plea agreement goes further, though, and says that you will be granted probation for a period of 8 years, provided you pay the financial obligations that I've outlined, including the additional sum of $90 as a restitution obligation, and the $290 court cost and the $690 reimbursement obligation that I mentioned just a few minutes ago. The plea agreement also says you're giving up your right to appeal, and I discussed that earlier with you. And it says you will participate in what we call the TAP program, which is an assessment, treatment, or counseling program for people who are returning to the sorry, I said that wrong. You will participate in the TAP program as a part of the terms of your probation, which is an assessment, treatment, and counseling program for people who have drug or alcohol-related problems. Now, that's the basic terms of the plea bargain agreement, including the 8-year probation aspect of the plea agreement. Now, that's my understanding of the terms, the basic terms of the plea agreement. Is that the same as your understanding of those basic plea bargain agreement terms?
Yes, Your Honor.
And are you asking me to approve and follow these plea bargain agreements?
Yes, Your Honor.
Ms. Brooks, have I stated the plea agreement accurately as you understand it to exist?
Yes, Your Honor.
And Mr. Smith, have I stated the plea agreement accurately as you understand it to exist?
Yes, Your Honor.
I just noticed this in the plea bargain agreement aspect. Mr. Dreger, you signed saying that this is your plea bargain agreement and you're entering into it, as well as your attorney, Ms. Brooks, and the state's attorney, Mr. Smith. But you also signed the line for the court's approval, to note the court's approval. And I'm going to suggest, I'm going to mark through that and sign my name, but I'm going to suggest here on the record that a better way to keep these papers and your plea bargain agreement for the term of your plea is for us to reprint the second page, and you and your attorney and the state's attorney sign it, then present it to me for my signature to note my approval. I do state that I approve of the plea agreement and I will follow it. But we will bring those papers to you, and then, well, we'll take it to your attorney first and then to you. Y'all are in separate rooms and not here in the courtroom, but you are here in the courthouse. So we will bring those papers to you just shortly. That said, do you have any questions about the plea bargain agreement as I've announced that I am approving that plea agreement? Do you understand what I'm approving?
Yes, Your Honor.
All right, sir. Then let's go forward and complete this plea situation. Based upon your plea bargain agreement, as I was announcing a while ago, I find you're guilty of the offense of driving while intoxicated, a third-degree felony, as alleged in the indictment. And that said, do you know of any legal reason why a sentence should not be imposed at this time?
No, Your Honor.
Then, following this plea bargain agreement that we just discussed, I'm going to follow that plea agreement and order you to serve 8 years confinement in the Texas Department of Criminal Justice, the institutional division, sometimes called the penitentiary. But I'm also going to follow your plea agreement and suspend the imposition of the confinement and instead place you on probation for a period of 8 years, provided you follow all the rules of probation. So let me ask you some questions before we talk about the rules of probation. I'm also going to assess a fine as provided in your plea agreement totaling $1,600, and I'll order you to pay court costs in the sum of $290, as well as to pay reimbursement fees totaling $690, all of which are also referenced in your plea bargain agreement. So let me ask you, do you know what the terms of probation are that you will have to follow?
Yes, Your Honor.
Did you have a chance to go over those terms with your attorney before submitting all these plea papers?
Yes, Your Honor.
Do you understand what the terms of probation are that you will have to follow?
Yes, Your Honor.
Can you follow the terms of probation?
I'll do everything possible. I will.
All right, sir. Do you think any of these terms are not possible?
No, sir.
Um, are you able to read and write the English language?
I can read a little, but I cannot write.
Could you read the rules of probation that you have to follow?
Yes, Your Honor.
And I ask it that way because we're going to provide a copy of the rules of probation to you. And you will have a chance then to read those rules whenever you need to have your memory refreshed about the rules. Is that acceptable and something you can do?
Yes, Your Honor.
Then I'm not going to read all of these rules to you right now. Instead, as I said, I will give you a copy of the rules so you can read them whenever you want to, but I will mention some to you just for emphasis. These are some of the rules that I see most often violated by probationers. And since we don't want you to violate your probation, I want you to be able to maybe have some of these emphasized. And then I'll give you a chance to ask any questions you have about any of the rules, including the ones I emphasize. So first, let me emphasize, you do not break the law while on probation here or anywhere else. You cannot expect to stay on probation if you're out there breaking the rules or the law. Do you understand that?
Yes, Your Honor.
One of your rules is you stay away from drugs and alcohol. Alcohol especially, because this is a driving while intoxicated offense alleging the use and even the misuse of alcohol. So you'll stay away from alcohol while you're on probation. You'll not go to places where drugs or alcohol are sold, served, consumed, or possessed, which means you'll just stay out of those places entirely. You will not have alcohol at your home. You will not go into places, but I will make some exceptions. You can go into a grocery store to buy other things, just not alcohol. You can't possess or consume or purchase alcohol in a grocery store, but you can go into the grocery store. You can also go into a convenience store. A lot of people buy fuel for their vehicles at a convenience store, even though a convenience store often sells alcohol. You just cannot purchase, consume, or possess the alcohol. And last exception, you may go into a restaurant, even though that restaurant sells alcohol. You just can't buy the alcohol, and you can't be with other people who are drinking the alcohol while in a restaurant. Do you understand that?
Yes, Your Honor.
While on probation, you will report to the probation office here in Snyder, Texas. You'll do that every month, and you'll do so before the 5th day of every month, unless special provisions are made between you and your probation officer and approved by me. I'm told that you reside at 10640 County Road 3195 here in Snyder, Texas. Is that correct?
No, Your Honor, it's 3155, County Road 3155.
And it's very possible that this says 55, and the top part of it is a little bit close to the rest of it, thus making it look to me like a 9. So that's why I asked the question, so we get it straight. So it's County Road 3155 here in Snyder. Is that correct?
That is correct.
All right, sir. Then you will, as I say, you will report to your probation officers here each month. You will live at that address at 10640 County Road 3155, and you'll not move someplace else unless you get permission from your probation officers. Now, permission is usually pretty easy to obtain from the probation officers. They're not trying to keep you from moving. They just want to know where you're going to be living and to make sure that that's not someplace that will cause you to get your probation in trouble. While on probation, you will pay off the fine, the restitution, the court costs, and the reimbursement fees. All of those together total $2,670. Are you able to pay that sum of $2,670 in one lump sum payment?
No, Your Honor.
Are you asking permission to pay those sums off on a monthly basis?
Yes, Your Honor.
Do you understand that you also have to pay a $60 per month court supervision fee?
Yes, Your Honor.
So how much do you wish to pay, and are you asking permission to pay to discharge your obligation to pay the fine, the court costs, the restitution, and such? How much are you asking to pay those obligations?
As low as possible.
Did you calculate how much that would be?
I have not been able to work since before Christmas, so I'm struggling trying to find a job.
Your Honor, I believe for 8 years, 96 months, it was about $28 is the lowest.
All right, I was coming to that same conclusion. Mr. Dreger, based upon all of your circumstances and your income, can you pay all of those sums at the rate of $30 per month, in addition to the $60 per month supervision fee, all of that then totaling $90 per month? Can you do that?
Yes, sir.
All right, I will approve that request and make that the term of your probation. So you pay $30 per month to take care of your fine, court cost, restitution, and such, and an additional $60 per month to take care of your probation supervision fee. Which you will do before the 5th day of every month. Let's see here. There are other terms I need to discuss with you, and let me go over some of them. First of all, I say first, another rule among the rules that you'll have to follow, so it's not the first, it's one of the rules. You not only will report to your probation office each month, but you will let them know each month where you are residing, where you are working, where you are living, so that they can adequately supervise your case. Do you understand that?
Yes, Your Honor.
Sorry, had something in my eye. All right, while on probation, you will not leave this county for more than 3 days. That's 72 hours without written permission. Because this is a felony DWI conviction, the law requires you to serve, unless there is some agreement to the contrary, a minimum of 10 days in county jail. I require that to be 10 full days, and so I order you to serve 240 hours in county jail. I will give you some say as to when you report to start that 10 days. Do you have a request for a time to start your 10 days?
Your Honor, or is there a way I can have a breakout room with Mr. Smith real quick?
The real quick is the problem that I'm having with your request. I will get it accomplished, but it may not be, I don't know your definition of real quick. Let me get that accomplished.
Thank you, Your Honor.
All right, you're about to go into the breakout room. You can control when you're through and you can come back and I'll wait for y'all to come back.
Thank you, Your Honor.
You're welcome. Mr. Dreger, they'll be right back with us. We'll be in recess for just a moment or two until that occurs. If you will remain there,
Yes, Your Honor.
we're almost through. We'll be right back.
Said that they will be right back.
Thank you, Your Honor.
You're welcome. Are we ready to resume?
Yes.
Yes, sir.
All right, then for the record, we're back on the record in cause number 10,858. Style, the state of Texas versus Jacob Fair Dreger. The record will reflect that in this Zoom remote video teleconferencing technology hearing, both attorneys are present in the virtual courtroom. Mr. Dreger is also present in this courtroom, and we're picking up where we stopped. Mr. Dreger, I was outlining some of the rules of probation that you have to follow, and one of the rules, which is required by state statute, is that you serve a minimum of 10 days in county jail. In order to make sure the minimum is actually served, I order you to serve 240 hours, which is 10 days, 24 hours times 10 days. But I will give you some input as to when you would like to start serving your 10 days. So let me ask you, when do you wish to start?
Could I do it on the weekend, starting next weekend? In case I get to be able to work, so I can work during the week and then serve the weekend, Saturday and Sunday.
Well, do you have employment right now?
Well, he hasn't fired me, but he hasn't given me any work. Every time I talk to him, he said, "I'll call you."
And when did he tell you this?
This is about 3 weeks ago. I think he was waiting on the trial to go past and go from there.
And who is this employer?
Abel Escobedo.
And what will you do for Mr. Escobedo?
We do construction work for different companies like Kinder Morgan, Scout Energy, Cut Energy.
So this is oil field construction, is that right?
Yes.
Weekend service creates several problems. Let me think about it for a moment. Give me just a moment.
Yes, Your Honor.
State, do you have any objection?
No, I don't, Your Honor.
All right. I'm going to approve your request to serve your 240 hours on weekends. And I assume you are, but I don't want to assume, so I want to ask you directly. Are you ready to start that? This coming Friday?
Yes, Your Honor.
Now, there's another possible way to do what you are talking about, and that is to start your 10 days and then modify your terms to allow you to do them on non-working days, but that's going to cause an extra good bit of work. I'm not sure you can come in and volunteer to start your days without a court or without the order specifying. So I'll prepare the order to say you will begin at 6:00 p.m. on Friday, March 5, and you will stay in jail until 6:00 p.m. on Sunday, March 7. Each of those marches that I've referenced refer to March of the year 2021. That means you would serve 5 consecutive weekends. Rather than 10 consecutive days. I'm sorry, that, yeah, that would do it. But here's one of the problems, and the reasons we don't do it on a regular basis is because you have the obligation to report to the jail at 6:00 p.m. on Friday, each of the next 5 weekends. If you don't show up to report, that would be a violation of your probation, and it not only would cause you to be put in jail, and it could cause your probation to be revoked. It also could be considered as an escape, which could cause a new charge to be filed against you. Do you understand? There are some potential problems that you will face if you do not follow the requirement to show up for doing your 10 days each of the next 5 weekends.
Yes, I understand, but I also wanted to see if you prefer, I'd do it all at once, 10 days at once.
Well, that's the court's preference. It's easier for the court. It's easier for the sheriff's office. And quite frankly, it's easier for you. I was just trying to see what we could do to accommodate your request. So are you ready to do the 10 days straight?
Yes, whatever it takes.
All right. What I will give you a choice as to which day you want to start.
Start next Friday?
Friday the 5th?
Yes, Your Honor.
That's this coming Friday.
Yes, Your Honor.
Do you want to start in the evening at 6:00, which means you will go 10 days and get out at 5:59 10 days later? Is that what you want to do?
Yes, Your Honor.
All right. Then let me write that in. So you will report on March 5, 2021 at 6:00 p.m. to the Scurry County Jail. You will stay there for 240 hours, which we've already discussed is 10 days. And then you will go to the probation department the following Monday, which I didn't look at the calendar for that. But whatever the following Monday is after you're released 10 days later. Oh, that's not a Monday. Let's look at that. It is a Monday. But it will be a Monday evening. The day after you are released, you will report to the probation office to begin following the rest of your probation. Do you understand that?
Yes, Your Honor.
Okay. Now, I used the word to begin. Your probation is going to begin today, and I'm going to direct you to the probation office today to get a copy of your rules of probation and to discuss your reporting obligations and those rules with your probation officer. But the day after you are released from the 10-day, 240-hour detention in the county jail, you will report that day also to your probation officer. And then each month, You will report to your probation officer at a date and time set by your probation, set with you by your probation officer. Do you understand that?
Yes, Your Honor.
All right. While on probation, you will observe a curfew. You will also perform 160 hours of community service restitution, which is work that you will do as a part of your probation. The probation office will discuss with you where and how to get your community service hours of work. While you are in jail doing your 240 hours, if there are opportunities to work in what we call the work program, the jail work program, also called the Orange Crew, we will give you that opportunity to get some of those community service hours done even while you're in jail. That's not intended to be additional punishment. That's intended to give you an opportunity to get some of those hours out of the way while you're already in jail. Do you understand that?
Yes, Your Honor.
All right, sir. Then the next rule is that I want to discuss with you is that you are to report on the 10th day of June 2021 to my court for a probation performance review, where I check to see how you're doing on probation, to make sure you're doing everything you're supposed to. If you are doing everything you're supposed to do on probation, we will say, good, that's what you're supposed to do. If not, then we will redirect your performance, because our purpose is to try to make sure you satisfactorily complete your probation. I have 2 sessions for probation performance reviews on June 10. One is in the morning at 9:30, one is in the afternoon at 1:30. I will give you your choice of which one to report for. Do you prefer to report at 9:30 in the morning or at 1:30 in the afternoon?
1:30 in the afternoon.
All right, sir, I will give you that opportunity, and that will be a part and condition of your probation. Now, these are not all the rules that I've discussed with you. There are others. Those are just the ones that I emphasized because I've seen them cause trouble for other probationers in the past, and we don't want you to have problems while you're on probation. But since I mentioned these and tell you that there are other rules of probation, let me give you a chance to ask any questions you might have about any of these terms of probation. Do you have any questions?
No, Your Honor.
Ms. Brooks, do you have any questions?
No, Your Honor.
Then those will be the orders of the court. Your thumbprint, Mr. Dreger, is required on this judgment. I will cause the deputy to come to your Zoom kiosk room where he will take your thumbprint, and then you will be directed to the probation office, which is located directly across the street from the courthouse on the west side of the square. Now then, do you have any questions about that?
No, Your Honor.
Then we will be in recess. And as I said, your thumbprint will be required. Thank you. Have a good day.